probably after the lunch. Very difficult to continue the activity. I welcome everyone here, and I welcome for the third session on business capital gains and development agreement. We have our faculty and speaker Mr. Sunil Arora from Delhi. I request Mr. Sunil Arora to come on the line. Around a big round of applause for the speaker. I request Mr. Sunil to give a moment of debate to our speaker. Thank you. Mr. Sunil Arora qualified as chartered accountant in the year 1983, postgraduate from Delhi University, and ranked third in All India in the 10th examination. Practicing since 1983 as a senior partner in Mr. Sunil Arora and Associates, having his head office at Sutherland and Delhi. Elected to North India Regional Council of Institute of Chartered of India for the term 2001-2004 and 2004-2007. Mr. Sunil Arora has been guest faculty in the number of workshops and training programs organized by ICI for various organizations namely PNAB, PHCL, IOCL, HPCL, NHPC, NTPC, etc. Mr. Arora has delivered lectures and presentations on various topics of professional interest and various forums. So today's topic is capital gains and development agreements, and since morning we have this topic coming up again and again. We had a chairman who started with the session stating that the development agreements, the taxability is coming at the time of agreement, which is coming with various issues, and our chief guest has said that it has to be taken case-to-case basis. So let us to get more clarity, we request our speaker, Mr. Sunil Arora, to put more light on the subject. Over to Sunil Arora. Thank you. Thank you, Mr. Becker. Chairman of the branch, Mr. Yaya, Mr. Becker, Chairman Kasa, Mr. Ramamurthy, Secretary of the branch, other senior members as well as members from the executive committee, and last but not the least, Mr. Venkateswarlu. I must say that I am here only just because of him, because he has such a persuasive style of, such a polite and persuasive way of telling you that you can't possibly say no. And when I told him that there will be summer vacations, members possibly would be out of station, even I might have to travel, he said, doesn't matter. We'll give you a post-lunch session. So as it is also half the members will go out to sleep. So you won't have to stress much. Now, so in case I put you off to sleep, kindly let me know. And if I'm disturbing your sleep, that also you can let me know. Okay, now I think the issue has already been raised by Mr. Mittal, and I'm sure it must have been raised in the morning session also. As far as taxability of development agreements and collaboration agreements is concerned, I think this is the right city to be discussing this at length, because there are so many decisions of the tribunal, Hyderabad bench of the tribunal, which have created this issue. I'm sure a lot of you must have had the occasion to argue these matters before, not just the assessing authority, but the appellate authority as well as the tribunal. Now, we'll discuss this and we'll see how the problem has arisen and how do we tackle it. When we talk of development agreements, primarily we are talking of an agreement wherein the landowner enters into an arrangement with a third-party developer whose
who has expertise would be developing this, and either the developed portion would be shared between the parties, or they would ultimately dispose of the entire developed area and share the sale proceeds. This is normal how we look at a development agreement. We'll see how is it different from the Chhatrapur Dwarkadas Kaparia as well as the Veer Singh Sarkaria's arrangements which were there. Okay. Similar to that is that you have a residential house, an old residential house. You enter into an arrangement with the developer. The developer reconstructs it into various floors or flats as the case may be, and the flats are shared between the developer and the landowner. Now these are the basic type of agreements, development agreements which take place. Now there is obviously some amount of payment also involved in this. Besides the construction or the development cost, there is some amount of cash consideration, which is either a part of it is paid in advance, upfront payment is made, some payment may be made subsequently during the course of the development or after the end of the development or as the case may be. So there can be various types of arrangement, but basic principle remains that the development agreement, there is a development taking place and there is sharing of the developed area or the sale proceeds arising from that developed area. Yeah. Absolutely. Yeah. No, I have not understood the question. I mean, land, because if you have developed.
It was finished, no?
Okay. Now, I think the first issue which arises, we'll take up your question as and when we reach that stage. Now, the first issue which arises is that the income of the landowner, will it be construed as a business income or will it be a capital gain in the hands of the landowner? Now, this will really depend upon the facts of the case to determine whether the land is held as a capital asset or a stock in trade. Now, as far as this issue is concerned, the intention of the landowner, for how long he has been holding, when he had acquired, for what purpose he had acquired, all of these become relevant. And the complete facts and circumstances of the case have to be seen to determine whether it is a capital gain or it is a business income. Now, capital assets, we are all familiar with, barring stock in trade, the rest everything, the relevant part of it is a capital asset. So in case the asset has been classified by the landowner as a stock in trade or as a business asset, then the income from that will be assessed under the head income from business. Otherwise, it would fall under the head capital gains as a capital asset. So it would depend upon the classification or the purpose of acquisition of the asset by the landowner. There was circular number 4 which was issued in 2007. Now, this circular basically is pertaining to shares and classification of the income from sale of shares, whether as a business income or a capital gain, but the broad principles which have been talked of apply in the case of immovable property also. And in fact, the circular number 4 2007 did not come up with anything new, and what it did was only highlighted some of the existing rulings of Supreme Court which were there, whether it is a Associated Industrial Development Company or H. Malla Classes case, and then we have those Swami Naidu's case. Now in all these cases, we need to first determine whether the asset which is being put into the joint venture or put into the development agreement, whether it is a business asset or is it a capital asset. So if it is a capital asset, then the income from that would be assessed under the head capital gains. We had a draft instructions which were issued on 16th May 2006. Now those instructions tried to list down various attributes which need to be examined. This was also more relevant for shares and securities, but the same principles can be followed for the purpose of immovable property also. Now without going into too much details of this classification, because the topic is capital gains and development agreements, so I'll restrict myself to the capital gains. Presuming it is a capital asset, the income is to be assessed as capital gain, then how do we go about it? Now, as I look at it, there are three issues which arise. First and the foremost is, what is the capital asset which is getting transferred as a result of entering into the development agreement? Second is, at what point of time the transfer is taking place to determine the year of taxability? And last of all, how do we ascertain the full value of consideration which is being received as a result of transfer of the capital? So only these three questions are relevant for which we need to determine, or we need to see the principles based on which the computation will be arrived at. In any development agreement, the kind of development agreement which we talked of, we come to the other kind of arrangement also subsequently. But then, when we look at it, the developed area, land, building, whatever, there has to be some sharing between the owner and the developer. So the area which is passing through the developer, that is the area which is a capital asset getting transferred as a result of the joint development agreement. And the taxability of this transfer which is taking place is a subject matter of review as well as whatever discussion we have. So as a result of the collaboration agreement, some proposal
it would be the fair market value. But what is your...
So what we are saying is that ultimately what the development has taken place, post-development, the owner's share, he has sold his flat also. He has crossed the second bridge also. So he has come to you only after that. And let me reach that stage, let me answer.
He will never come to us to draft the sale come GPA, because he will only come after he receives the money in his account, after selling the flats.
No, but then the first stage you will be there when you are entering into an arrangement with the developer. At that particular stage, you are not involved, the development has also taken place. And then he comes to you once the flats have been received and then he has sold those flats. Okay, so now you have no choice but to relate it to the year in which it relates and then file a revised return or something like that. Because you can't offer it for taxation subsequently. I mean, if that stage has already passed, so if you offer it for subsequent year, demand will get created in that particular year. So you have no option but to revise that particular return. So you will have to see on the facts of the case. Okay, so now let me just complete this portion, then I have one question on 50C as well as a few more questions, then we can take it up I think later. Okay, now the one issue which is another second part of this issue is that the capital gain which I am making on entering into this development arrangement, can I take exemption under section 54, 54F, 54EC or 54E as the case may be? Now for this purpose, what is happening is, let's suppose a residential complex is being developed. I am receiving 6 flats, the builder is getting 4 flats. Now my contention is that this 6 flats which I am receiving, the construction cost of this flats is in a way my construction of a new residential house, so I should be entitled to exemption under section 54 of this particular law. Just to recapitulate, I'll just briefly run through the section so that we are of the same mind when we are discussing this. Section 54 we are all familiar with. If any individual or an HUF transfers a long-term capital asset, being the building and a land appurtenant thereto, the income from which is chargeable to tax under the income from house property as a residential house, then if he constructs a residential house within a period of 3 years from that date, then the amount of capital gains, to the extent they have been utilized for construction of the new residential house or purchase of the new residential house within a period of 2 years, are exempt from tax. Otherwise, the said amount will become liable to tax, and if only a part of it has been invested, then the remaining will become taxable as capital gains. Now there are conditions that this new residential house should not be transferred for a period of 3 years, and in case it is transferred, then the taxability of this would be taken as the cost of acquisition would be taken after deducting the amount of capital gain exemption which we have taken. Now there is the basic section 54 which we are all familiar with, and then we have section 54F which says that in case individual or an HUF has transferred a long-term capital asset other than a residential house, and if within a period of 2 years he has purchased a residential house or within a 3 years he has constructed a residential house, then he is entitled to the exemption of the taxability. But there are some conditions which he needs to be fulfilled. First and the foremost is that for 54F, the assessee should not own more than one residential house. Otherwise, he does not become eligible for Section 54F. Second is that he should not purchase or construct any other house within a period of 2 or 3 years, as the case may be thereafter. Otherwise, the eligibility or the exemption which he has availed would stand withdrawn and the amount would become taxable in that. Now, for 54F, the net consideration has to be invested instead of the amount of capital gains. Only the net consideration has to be invested, and proportionately the amount would become taxable under Section 45.
Here, what is the net consideration? Is it under 50C or actual consideration?
Okay, now we get diverted to 50C as well as 54 complexities. I wanted to remain only on the development agreement. Okay, let me see. At that time, I will address your question also. Now, if you look at 54 and 54, 54F applies to transfer of a capital asset other than a residential house, so they are both mutually exclusive to each other. Either 54 would apply or 54F would apply. In 54, there is no restriction on ownership of a house. I can have 10 residential houses, I can sell any one of this, purchase 11 and entitled to exemption. Whereas Section 54F, there is a restriction that I should not own more than one residential house other than the new house against which I am claiming the exemption under Section 54F. For 54, the capital gains have to be invested, whereas for 54F, it is the net consideration which has to be invested. Now, in 54, there is no restriction. I have 10 houses, I sell one, purchase 11th house. After 3 months, I purchase one more house, there is no problem. I am entitled to exemption on the capital gains which I take, exemption which I avail against the 11th house. Whether 12th house will be there or not, that is a subject matter of debate, but then 11th house in any case, the exemption would be available. On the other hand, in 54F, if I purchase a house like this, then the exemption which I avail against the first house would also be gone. So it will stand withdrawn and it will become taxable. Similarly, in case the new asset is disposed of within a certain period, then also the taxability is different under Section 54 and 54F. The first issue which arises here is that in most of the development of the collaboration agreements, it is a repurchase of my own property, in the sense that where is the new property? What is happening here is that I have entered into a development agreement, the developer has constructed say 12 flats, 4 flats he has retained, 8 flats he has given to me. Now, this 8 flats, is it a new house, new residential house which I have purchased? Now this came up before Bombay High Court in Feroz H. Patel's case, wherein Bombay High Court said yes. This is a construction of a new residential house and the assessee is entitled to exemption for repurchase of the same property for which he was the owner earlier, in case it is a development of a new house. So now whether 54 would apply or 54F would apply, this itself would become a matter of debate, because if 54F applies, then there are a lot of restrictions on me. I may be eligible for 54F, I may not be eligible. So now, if I am entering into a development agreement, am I covered under Section 54 or 54F? This is the first issue. If the residential house is getting transferred, then in that case, 54 would apply. In case land is getting transferred, only land I am entering into, then in that case, 54F would apply. The second problem which arises here is that in most of the development agreements, I would be getting more than one flat. Whereas a residential house talks of, there was a dispute on this, whether one residential house means, a residential house means here one residential house or more than one. The matter, Bombay Special Bench, Sushila Jhaveri's case said, unless and until these are two adjacent flats, exemption would not be available. This is what ITAT Special Bench said in Sushila Jhaveri, which I am sure we all know. There were contradictory judgments earlier. Section 13.2 talks of that unless and until there is a specific restriction, the General Clauses Act 1897 says that by interpreting any statute, the words used in singular would include plural and vice versa, unless and until it has been specifically provided, it has been specifically restriction has been imposed in the statute. So if we go by General Clauses 13.2, a residential house does not restrict the purchase of one property, it can extend to beyond one also. Then there are other judgments also. I am not going into those judgments because the relevant here is two judgments which are there. One is the Karnataka High Court judgment in the case of K.T. Rukmani Amma, and with this judgment has been followed subsequently by Delhi High Court in the case of Geeta Duggal. In both these cases, the SSC received more than one flat as a result of development agreement. Both of them were pertaining to development agreements. The SSC received more than one flat. In Karnataka High Court judgment of in Rukmani Amma's case, the SSC received 4 flats and claimed exemption under section 54 on all the 4 flats, wherein the department said only one house is available. The Karnataka High Court said that section 13(2) would apply and a residential house would mean 4 houses also and the exemption would be available. Delhi High Court, similar issue. The SSC received 3 floors, in fact 4 basement ground, first and second, third floor went to the developer. In Geeta Duggal's case, the Delhi High Court followed the ratio of Rukmani Amma's case, Karnataka High Court, and also added one more thing there and said there is a difference between residential house and a residential unit. One residential house may consist of a number of residential units. I may have 4 units in one residential house depending upon my requirement. So the language of section 54 is residential house and not residential unit. So a residential house, in this case, 4 different floors, 4 different residential units may constitute one residential house, so the exemption is available. So as far as development agreements is concerned, even if you are receiving more than one residential house, the exemption would be available to the SSC. Now, to avail exemption under section 54B, in case the collaboration of the joint development agreement has been entered into pertaining to an agricultural land, then I can avail exemption under section 54B also. But depends as to whether my land would get classified as an agricultural land and whether I fulfill the conditions of section 54B, then I am entitled to claim exemption of this agricultural land also. Now what is an agricultural land? There are innumerable I would say rulings on this of Supreme Court as well as various high courts. Siddharth J. Desai, Gujarat High Court has listed down all the attributes of a agricultural land and have tried to arrive at what is an agricultural land. Now, agricultural land as far as the Income Tax Act is concerned enjoys certain privileges. Agricultural land beyond the municipal limits, certain areas out of the notified area is outside the purview of section 214, not liable to be taxed at all. Compulsory acquisition is not a subject matter here. And agricultural land transferred and another agricultural land purchased enjoys exemption under section 54B. Now the definition of agricultural land, which was there, has undergone a change with effect from 1/4/2013. Earlier it was the agricultural land definition was beyond the notified distance of the municipality. Used to be agricultural land inside the municipality and inside the notification. Although agricultural land was a capital asset liable to be taxed, whereas outside that was totally outside the definition of capital asset, not liable to be taxed at all. Now the definition which has changed now with effect from 1/4/2013 is that if the agricultural land is within a municipality and the municipality has a population of less than 10,000, then it is not a capital asset under section 214 at all. And if the municipality has population exceeding 10,000, then within the municipality agricultural land is a capital asset liable to be taxed. And the second part of it, instead of notification, they have specified the distances now, that outside the municipality, if the population is less than 10,000, then any land outside the municipality would not be a capital asset and will not be taxable. If the population is between 10,000 and 1 lakh, then 2 kilometers is the area which has been fixed. If it is more than 1 lakh and less than 10 lakhs population, then 6 kilometers the area which has been fixed, and similarly beyond 10 lakhs is 8 kilometers. that means beyond 8 kilometers from any municipality, agriculture land would be a rural agriculture land outside the definition of 240, not liable to be taxed at all. But the problem is that if it is within that distance and a joint development agreement is entered into, can I avail 54B on this? Yes, 54B can be availed on this. If you are fulfilling the conditions of section 54B, in spite of this joint development agreement, you can claim the exemption under section 54B. One issue which you have to remember is that in all such cases, the developer would be taking the property not for the purpose of agriculture, but for the purpose of development into either a commercial complex or a residential complex or whatever it may be. So will this lose the character of an agriculture land? Now here, there is a Punjab and Haryana High Court judgment in the case of Savita Rani, wherein the Honorable Punjab and Haryana High Court said that the purpose for which the transferee is purchasing the land is not important. In the hands of the SSC, if it was held as an agriculture land, the exemption would be available to the SSC as a result of this. Now, so we have 54, we have 54F, 54EC is in any case available, and we have 54D also. So some of the issues which arise, let's suppose I do like this, that I have a residential house, I demolish my residential house, and then I enter into a joint venture development agreement with the builder to develop flats thereon. Will I be entitled to 54 or will I be entitled to 54F in this one? Because what is getting transferred is land, not a residential house. So I can have a problem here. So I think one planning which you can do is because 54F would have only a very limited application. 54 has much wider application. So as a result of this, it would be in any case advisable to be in 54 than in 54F. Second kind of situation is that you have a huge land and you have a small residential house there. You enter into an arrangement where residential house remains intact and the extra land is used for the purpose of development of a residential complex there. And here again the same problem would be there. You would get covered under 54F and not 54. So you will still have a problem here. Now how do you structure the transaction? You need to see that you remain under section 54. And one mistake or one problem which always comes, especially in the kind of cases which my friend was referring here, the SSC has already done everything and then he comes to you. So then you don't have much to do. The issue here is, normally a developer would not get the CLP registered in his name. He would like to apply for a CLU, change of land use license and everything in the name of the landowner. And once those provisions come, then he would take the transfer in his name. So now, in case the transaction is structured like this, what would happen in the hands of the landowner? Now, let's suppose it is a case of a farmer. He is doing agriculture activity on some land. Now, the developer tells him, gives him an advance and tells him that we will apply for a CLU in an LI in your name and all those things is done. So once all this is done, and then a transfer is taken from the landowner, so it loses the character of an agricultural land itself, and it becomes, he would not be entitled to benefit of section 54. Now such kind of transactions you need to structure because the tax liability may be huge. And most of the time you will find that the landowner would be preferring to purchase some other agricultural land. Now in such cases, you need to structure a transaction in such a manner that the transfer takes place first in favor of a third entity or a company. Let the person take benefit of the agricultural land exemption which is there either 214 or 54B as the case may be, and then subsequently you apply for all those things, as a result of which the exemption of the SSC is not hampered. This is what we need to see and we need to guide. The second, now in fact the next stage here is a number of landowners would like to dispose of the share which they have also received, like what you were mentioning. There are issues which arise as far as this is concerned. First of all, whether this will be a short-term capital gain or a long-term capital gain. Now, are you with me? Or you are? Yes. So I think organizers were enough to get the tea served. They said that everybody has gone off to sleep, let them give them a morning tea at least, wake up call, wake up tea. Okay, now the issue here is that I have entered into an arrangement with the developer, I get 4 flats. I dispose of these 4 flats also, separately out of my share. So we talked of taxability of the first stage where I have entered into an arrangement with the developer. Now the second stage taxability means when I am selling these 4 flats, what is the taxability? First of all, whether it is a short-term capital gain or a long-term capital gain and how the cost of acquisition will be computed in this case. Any ideas on this? Absolutely. So it is both. To the extent of the land component, it will be a long-term capital gain. To the extent of construction part of it, it will be a short-term capital gain. And most of the time you will find that the gain would be on the land component, not so much on the construction part of it. So the gain would be a long-term capital gain. There are a number of rulings on this. Kerala High Court actually already speaking orders are listed on here, but then there are a number of rulings on this. Second issue was that how do you ascertain the cost of acquisition in this case? Now, one suggestion which I can tell you is that if the SSC is getting 54 on the cost of construction and it doesn't intend to sell it immediately, it is better to take the maximum cost of acquisition here because it will help you, it will reduce your tax liability when you are subsequently selling this. It would not tax you at the stage, at the first stage, and it will reduce your tax liability at the subsequent stage. So, whatever amount you show as this full value of consideration at the first stage will form a part of your cost of acquisition in the second stage by which you can use this. Now, okay, let me just take up a few questions which were raised. One question was regarding the 50C, whether 54F, whether it will be the net consideration here would mean the actual amount received or will it be the settle rate as per which 50C is taxable. Now there is already a tribunal judgment on this. I think our President V. Putrappa, he has pronounced one judgment on this, Bombay tribunal judgment on this, wherein they have said that 54F, you can't have this interpretation being given to 54F that net consideration for the purpose of it would be only the net amount that has been received. So in other words, in case you are utilizing the amount equivalent to the circle rate, then you can claim exemption under section 54F or 54 or 54EC for the total amount. That is also debatable. But in any case, not at the lower amount. So 54 net consideration received, utilized for the purchase of the new residential house, will not entitle you to the exemption of the entire amount in that particular case. Okay, now that was one. Second question was regarding 50C. Yeah, just one second. Second question was regarding 50C on this transaction. As far as development arrangement is concerned, how can we fix the value of this development arrangement if it is a pure development arrangement where the developer is in fact carrying out development? If it is only a sham, to have a transfer of a property less than 50C is something different. I am not going into those details. But if it is a case of a genuine actual development arrangement, to my mind, 50C has no application here. Because 50C can be only measured in terms of value or in terms of money circulated there. It cannot be measured in the form of time, quality of development or the development which will be carried out. So to my mind, 50C does not apply as far as joint development agreement is concerned because this is not a case where the circle rate is a variable for development. You can't have a circle rate of development of a property. Okay, yes.
In my case, it is agriculture land. Land owners have applied for permission. And ultimately, in the passbooks also, the entries of agriculture land have been given. Sharp Allahabad High Court said the complexion of the land does not change, so that is why 214 exemption is available. So, in such a situation, what I suggest is the Supreme Court also there is no way citation opposing the type of land it is. So, can I be enlightened basically if there is contradictory decisions on this matter?
Now, as far as agricultural land is concerned, whether land is agricultural or land or not is a matter of dispute with the department, innumerable disputes with the department with the matter have traveled up to Supreme Court because there are huge tax liabilities with the difference in tax liability there. The reason being, agricultural land outside the municipality, which is a rural agricultural land, is not liable to be taxed at all. The moment it loses the character of an agricultural land, even if it is outside the notified area, it becomes a taxable asset.
Sir, in my case, it is still clear, they only applied for permission to permission. But ultimately what they have transferred in the village records is still of the category of the agricultural land only. It is still whatever the land has been transferred is still the passbooks, everything will be the decider is the same as the agricultural land.
Okay. So in any case, what you are saying is that the permission has been applied for, but it has not been done as yet, because once the permission comes, it loses the character of agriculture land as per the revenue records also.
No, in my case, it has not last.
It has not. It has not. So you have only applied for a permission. Now you can always have a case that this is my agriculture land. I am using it for the purpose of agriculture. I want to sell this agriculture land, and to maximize my gains, I am applying for a change of land use, and then I am selling it. Now what would happen is, if it is a genuine case of agriculture land, where agriculture operation was being carried out, revenue record that is an agriculture land, so there is no development around that land, so you have a positive case of an agriculture land. Now, in your case, even if you have applied for the permission, till the time the permission has not come, you sell that particular land, you are entitled to exemption in this case. The problem is mostly in those cases where the land has not been put to agricultural use, where there is a development which has taken place around that land, where the land has become so expensive that the agriculture operation cannot be carried out at that particular rates. The agriculture operation is not fruitful there. So keeping in view those lands, this issue which I have discussed, but in your case, I think it holds good.
One more point.
Yeah.
Shahida Begum is the speaking judgment of Allahabad High Court.
Yeah.
That's what they reported that. That is the speaking judgment. And it has not been contradicted by other high courts. Is it not binding upon all parts of India?
No. The thing is that the ratio of one judgment of a tricky situation of agriculture land. Now, how far you can bind the other judgment is a subjective issue. You can't have it's not like a formula. It is not a H2O that it has to be water in Allahabad, so it will be water in Hyderabad also. It has to be, and the facts of the case have to be looked at in this particular case. Okay, now I think another very interesting kind of a situation is there, so I'll just address this. Now, yeah, please, you want to say something? I think we just wait for the mic so that everybody can take advantage of that.
The actual consideration is less than the consideration as per FTC. How do you expect the SEC to invest?
He can take a loan, he can have his past savings, he can dispose of some other asset. Sorry?
He has to do that, is it?
No, if you want to gain exempt, no, the thing is either you contest 50C.
That means the privilege given by the law players.
I would not say so, because you have the privilege to contest 50C. Now 50C itself, now actually I tell you, now there are 50C to my mind, it is more like a deterrent provision, but the manner in which the circle rates have been increased by the state governments, it has become more like a draconian provision.
That's true.
Because at some point of time, the circle rates were so reasonable that probably no land was getting or no property was getting sold at that particular rate. So to that extent, 50C was still acceptable. Now the problem which has come is that in a number of states, the circle rates have been increased to such an extent that 50% of the properties you find are not even fetching that much price. So that is a problem which is there. Okay.
Please, investment, borrow and invest. Borrowing is not objectionable.
Now, for a 50C, I would say to claim exemption, if he is borrowing, now that is, we'll get into total separate kind of a section. So that I think we need a separate debate on this topic. But then I can tell you, if we are investing the amount which is equivalent to the circle rate 50C amount by borrowing or from past savings or from any other source, you'll be entitled to the exemption. Even if the assessing officer does not allow you, subsequently you will get the exemption, and there will rulings which will come, because the structure of the act is like this. 45 is subject to 54, 54F, 54EC. So if 54F, the 50C provision only affects 48, it does not touch 45. So the structuring of the statute is like this, that if you are able to invest more amount, you will be entitled to exemption.
In fact, 50C is for calculating gains. 54 is only for the exemption.
Yeah, so what is happening is, okay, I just 1 minute I'll explain and then I'll proceed further. What is happening is 48 is the computation provision. 50C only hits 48 and says that full value of consideration will be deemed to be the circle rate. This is what section 50C says. Now this computation provision carried to the charging section under section 45 and 45 is subject to 54, 54 and 54EC and 54D as well as other exemption provisions which are there. So to my mind, 50C does not say that it will become taxable, it only says full value of consideration would be deemed accordingly. And full value of consideration goes to the charging provision that is section 45. So, and 45 is subject to 54, so the scheme is such that the SSC is entitled to exemption on that. Okay, one last thing which I, okay. Right.
But he has not deposited the capital in the bank, the balance.
Okay.
Sorry?
Sorry?
He will construct the excavation, right?
Yeah.
We can read. Time period given there.
Has he filed his return?
No, he has the need. He has not divided the income tax department.
Doesn't matter. Has he filed his return?
He filed return, gained exemption.
He has filed
before constructing the house.
Where is the money? Has the entire money been utilized for the new residential plot?
He has utilized certain portion for purchasing a land to construct a residential house.
Fine.
You can bring up 3 years, but the money is retained by him in his bank account only.
In the regular bank account?
Yeah.
And he has filed his return?
Yeah.
Then he is into problem. Then he has a problem. Yeah, there were 2 options. Let him not file his return, utilize that money, then file his return.
That means he has to file it after 2 years.
Doesn't matter, let him file the return after 2 years. You have 2 years time to file the return. And in any case, you get the entire assessment in previous year also. So practically in some cases, you may get 3 years. If the property transaction is taking place on 5th of April, you get practically 3 years up to 31st March. After 2 years, you can file that particular return. So what is happening? There are judgments, Guwahati High Court plus there is, I think, Bombay High Court judgment also on this, Rajesh Kumar Jalan and other judgments which are there, that even if you have utilized it before filing of return, you are entitled to exemption. But then, if you file the return and you have not deposited, then you can have a problem. So now you will have to make a case as to why you did not deposit it. I can give you a separate suggestion. Show it as that you have given it as an advance to the contractor and he is carrying out the construction. Issue the check, manage it somehow and then you can get the exemption. Otherwise, you have to okay.
Sir, this is last one.
Sorry?
This is last one. Sir,
Yeah.
sir, ideally, in a development comes GP agreement that a landowner enters with the landowner enters with the developer. So what we are doing only is we are straightaway applying the sale consideration, we are straightaway taking sale consideration as the value that will be used for paying the stamp duty. Can we do that? Because there is some value on this to pay the stamp duty. So can that value be allotted as a sale consideration? Because obviously in the eyes of the distributor office, it is the store market value, right?
Now, okay, so for computing, now the thing is that 50, you have to take that circle rate or the actual consideration, whichever is more, right? So
the actual consideration in this case is, we wouldn't know because, okay, you need
the
to
actual consideration is 2 parts. One is cash and the second is time. As far as the time consideration in the form of development cost, you can take a valuation from a registered valuer. So that would give you the value. And you can take a certificate from the developer as to how much amount has he incurred on this, or whatever amount he is going to incur. So that would become your actual consideration.
Okay.
So then you can compare it with 50C, but then 50C, how would you apply? In most of the cases, 50C is that you are giving a developed portion and it is not a consideration alone. Circle rate would apply only if the consideration is coming to you in cash. Here the developer is putting in his services also. So how would you value his services? So that is why I was saying 50C cannot be applied in this kind of a term.
So you would say the better option would be to obtain a valuer's estimate and
Valuer estimate and certificate from the developer also to the cost which he has incurred for in kind, whatever you are estimating. That would be a better way of doing it.
One question please.
Yeah.
Previous gentlemen also asked the same question. See, we all get clients, complete the project and come to us. Then what do we do?
Okay. First of all, I would suggest charge him an extra amount for the extra effort that you have to put in. So quote him a good price for whatever services you will be rendering, and then work out what he has already done and what he should have done, and then try to match it as per law what is possible, whether you can revise the return, you cannot revise, what you can do. So that would really depend on the facts of the case.
So we directly take it as a sale consideration and show it. What is the problem? Because we can't go back to the developer if it's more than 4 or 5 years.
Okay. So now, you may, in such a situation, you may land up in a problem that you are paying tax in the current year, whereas your tax liability may get affixed to a previous year. So what would happen is that this tax you already paid, it will become very difficult for you to claim a refund of this, and that liability may get affixed. So that problem you run that particular risk.
Better than not paying anything instead, because 94 I can't take it up.
Yes. So if it is a very old contract, then let it be out of, if it is outside that 6 years period 148, then it is better for you to put everything there. You can't have a better way. If you have something which is beyond 7 years and 148 is not possible, put everything there. You can't have a better situation there. But charge a good amount from your client for advising this.
Sunil, we cannot have more questions now. I think the discussion has one question.
No, I think I just complete this last slide, and if all there are any questions, we can take it up after the session, or we can take it up personally. Now, I think we all have a lot of cases like this. The SSC has booked a flat in say 2007. He gets the possession in 2011, and he sells it in 2012. So now, is it a short-term capital gain or a long-term capital gain? Now, prima facie looks to be a short-term capital gain, but then Gujarat High Court, in the case of Jilas Parchan Gandhi, said that the right which is there to that particular house is long-term because the right was acquired in 2007. And it is a case of transformation of a right. This right has got transformed into a flat in 2011, which has been sold in 2012. And the flat cannot be there without that right, and the right is also going along with the flat. And they said that because this is a case of transformation, it would be taken to be a long-term capital gain, and the SSC would be entitled to lower rate of tax exemptions and all those things the SSC would be entitled to. This was the case of a cooperative society, but the same logic has been followed by the front bench of IT18 in the case of Sharad Chadani. So in other words, such cases where prima facie it may look like a short-term capital gain, you can take the benefit of long-term capital gains here. I really appreciate the active participation, and my apologies for delaying the. I think he has already said last question. So can you just take it up after this?
On the same slide.
Okay.
If the flat has been sold on 2011 itself.
Fine, so it's a long-term gain. 2011 is not a doubt at all, because you rightly acquired in 2007 and you sell it in 2011 you mean after getting the possession.
Before getting the possession.
So it is a long-term capital gain, there is no doubt of that. So the doubt only arises if it has got transformed into a flat, then there is a doubt. So that doubt has been removed by the Gujarat High Court, which has been followed by the Gujarat High Court. I'm really thankful for a very active participation. Thank you.
We thank our speaker, Mr. Sunil Arora, for throwing light on such a lightning topic of capital gains and development agreement. I request my fellow committee members, Mr. Abhinandan, to start the board session on transfer.
Good evening, friends. We are coming to the last session. This is last session. Is not the least of anything. I think this is probably the best session. I would say. I think the organizers have celebrated this topic today because this is a very latest and a very hot topic. So my present duty is to introduce my young friend, Mr. Pankaj Jain. Before I really introduce him, I thought I'd share a few thoughts about the current topic, that is the transfer pricing for specified domestic transactions. Actually, this concept was basically for the international transactions, but recently there was a case of CIT versus GlaxoSmithKline Asia. In the Supreme Court suggested that the CBDT should consider making transfer pricing regulations applicable to specified domestic transactions. However, the Supreme Court said there are two instances where this concept is not relevant. One is the transactions are between loss-making and profit-making units. Second is transactions between two related units of the same taxpayer where there is differential tax rates. The 2012 Finance Act, by way of amendment, has brought even the domestic transactions to adopt. The most basic thing is the arm's length principle has been introduced, which was earlier the related party transactions was a fair value method. There are basically